The U.S. Supreme Court this week heard the arguments on two landmark cases involving same-sex marriage. Now come the educated guessing games as the justices deliberate rulings that probably won't come before summer, but may well change the definition of marriage in this country. For more, we're joined by Linda Greenhouse. She's a Pulitzer Prize winner, a reporter, and she's covered the Supreme Court for the New York Times for nearly 3 decades, and she is now a senior research scholar at the Yale Law School. It's nice to have you with us.
Nice to be here.
These are two deeply polarizing cases, very complex. What happened in the last week?
What happened in the last week, I think, is a little bit of the air went out of the notion that these are going to be landmark decisions. I think it's pretty clear coming out of the Proposition 8 case, the first case that was argued, the California case on Tuesday, that we're not going to see a sweeping ruling, actually, that changes the definition of marriage, neither yay nor nay. I think the court seems to be rather desperately looking for narrow grounds or even a way out of the whole case. On the second argument, the Defense of Marriage case, I think we will see the Defense of Marriage Act struck down, but not with very clear law coming out of it, not with very helpful law necessarily.
Not with unanimity among the justices about why they're striking it down.
Certainly not with unanimity. I'm not even sure with 5 of them agreeing on the same thing.
Right.
So the question is, where would the marriage issue go from there based on law?
And Linda, if there's so much uncertainty among the court about these cases, why do you think they agreed to take them?
Well, to start with the easiest answer first, the Defense of Marriage Act case, a federal statute was struck down by 2 federal appeals courts, and that's sort of the court's bread and butter business when a lower court has invalidated a federal statute. That was not at all surprising that they would take it. It was surprising that they took the Proposition 8 case. The lower court, the Federal Court of Appeals there, had issued really quite a California-specific ruling that doesn't really apply in the other 49 states. So you have to think it was part of an agenda by the conservative justices. They didn't like the lower court opinion. They don't like same-sex marriage, and they wanted to see if they could get their hands around this issue.
Is there any precedent, if you go back historically speaking, you look at constitutional law and what the Supreme Court decides to take or not take, for a case like this looking one way in the beginning and turning out much differently in the end?
Oh, actually, it happens all the time. It does happen all the time. And I should say, in terms of the issue that looks like it's going to trip up the Proposition 8 case, which is the standing, the ability of the Proposition 8 proponents to stand in the shoes of the state, which refused to defend Proposition 8. That's actually a substantial issue. When you have an initiative or a referendum that gets struck down and the state says, we never like this, and they don't defend it, sort of what's the political science of that? So, I wouldn't fault the court for thinking that that's an issue worthy of their attention.
Linda Greenhouse, thanks for joining us.